Hello everyone, welcome to this video. Again, my name is TaQuita Hogan-Claiborne from the Law Office of TMAC. I'm here making this video for you. You are just a few steps away from receiving your free special report entitled The Shocking Truth About Who Gets Your Kids, Your House, Car, and Money When You Die. But first, I want to begin by asking you two simple questions. Number one, do you have a will? If you do have a will, that's great. If you do not have a will, then question number two is for you. Do you think you need a will? If you do not, then why not? You might think that I'm not old enough, but anyone 18 years or older and mentally competent can have a will. Now, while minors can and do own property, they cannot make a valid will. You may also say, I don't own anything. But really? If you die, you have a car, you have furniture, you have a TV, you have clothing, you have jewelry, all of those items will be considered your property. Or you might say, I'm not married, I have no children. But what if you happen to be engaged? Then your fiancé gets nothing. And let's say your parents are divorced. Then your divorced parents, who don't get along with each other, each inherit a half interest in your car, in that furniture, in your TV, in your clothing, whatever it may be. And they don't happen to get along, but they will have to get along to sell the property. Is that really what you want? Okay, you say, well, I don't plan to die anytime soon, and I just feel uncomfortable thinking about it. Whatever the reason may be, you're not alone. Most Americans don't have a will. Actually, a 2007 national poll conducted by Bankrate Inc. found that over 57% of Americans do not have a will. What does that mean? If you don't have a will, what exactly does that mean? So without a valid will, state laws control who receives your property at death, as well as the exact amount that is given to each person. Thereby, your heirs are determined by law. Let's look at a hypothetical situation. Let's say we have decedent Dave. And decedent Dave did not make a will. He was survived by his wife and minor children. If the minor children are co-heirs with the surviving spouse, that means a guardian must be appointed for them. And the surviving wife will not be free to sell the property without first getting the permission of the probate court. This is going to require filing lots of paperwork, hiring an attorney to handle the paperwork, and leave less money for the wife and the kids to live on. What if the children have special needs? Special needs of heirs with disabilities may not be met. So without a will, how is it determined who receives your property? Again, the laws of the state of domicile of the decedent, this is the place where you reside, will determine who gets your personal property. What about your real property? Now, the laws of the state where the real property is located will determine who receives your real property. For example, maybe you live in Texas, which is a community property state, but you own a house in Tennessee, which does not recognize community property. Let's say you have decided to draft a will. That's great. This would allow you to control what happens to your property. So what we actually are going to discuss in this video is estate planning, which is planning for the transfer of a decedent's estate to take place either at or before death. It also provides for the handling of a person's property, which concerns while he's still alive, if he cannot handle that property himself. Estate planning includes the designing and preparation of a will and the naming of a person representing it, the making of appropriate pre-death gifts, probate of the will, the administration of the decedent's estate, and distribution of the assets. Also, the preparation and filing of all necessary tax returns. But good estate planning does these things in a way that is an advantage to the heirs and the beneficiaries, and it also takes into account of the advantages of favorable tax treatment whenever possible. In the next video. Okay, so you have some property and you have some idea about whom you want to receive the property at your death. Now we have to turn those ideas into something that the courts can use to make sure those ideas become reality. And the way to do this is by drafting a will. Wait a minute. What exactly is a will? A will is a written declaration of your intended distribution of property after death. If the will is valid, it will serve as instructions to the court on how to distribute the property, also called a testament. You must know that it is not enough just to have a will, but a testator must have a valid will. Now, let's determine when a will is valid. A will is valid if, number one, it meets the formal requirements for its creation. And number two, it meets the formal requirements for its execution. As well as number three, it does not contain any contradictions, ambiguities, or confusing words or phrases that might make the will invalid. For example, let's talk about for creation. For creation, it requires a testator or testratus, if it's a female, who has legal capacity, that's of sound mind, understand what making a will is about, and also have testamentary capacity. They know who their family members are and what property they have, and have some idea about which family members should receive which item of property. And for valid execution, the will must be either one of three types of wills. It could be a formal will, written and signed by the testator and by two witnesses, or a holographic will, written entirely in the handwriting of the testator, or a non-competitive will. These are spoken or recorded words when the testator knows his death to be imminent. Now here in Texas, your formal will actually goes through a execution procedure that includes publication. This is where the testator announces that this is his last will and testament, and also subscription, where you have the signing of the will by the testator, and attestation, where you have the signing of the two or more witnesses. Or if the testator wants to avoid this process, he can make an holographic will, or under some circumstances, there has been times when you can been allowed to have a non-competitive will in Texas. Don't forget that third requirement is also required for a valid will, where you have no confusion, no contradictions, or ambiguity. Now, a valid will, once you have it, can accomplish many things and avoid most of those problems we have talked about earlier as resulting from the failure to have a will. So, what did we learn today? Number one, if you don't have a will, your property shall be controlled by the laws of intestacy, which is also known as the laws of intestate succession. We covered several key terms such as heirs, beneficiaries, estate planning, estate, real and personal property, a will, and several other key terms. Number two, we also discussed how to determine if a will is valid. And three, as well as the three different types of wills. Attention. In the next video, we should begin reviewing property and the laws of how it relates to wills and probate. Thank you for your attention. See you in the next video.